Did the city of Kingston properly opt into the Emergency Tenant Protection Act in 2022? To find out, you have to read Matter of Hudson Valley Property Owners Association versus City of Kingston, but it's 14 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Matter of Hudson Valley Property Owners Association versus City of Kingston. The citation for this case is 2025 New York Slip Opinion 03691, published by the New York Court of Appeals on June 18th of 2025. The issue in this case is whether the City of Kingston, under the Housing Stability and Tenant Protection Act, properly declared a housing emergency and then made two specific rules about rental guidelines and rental rates. To understand and appreciate the context of this case, what's helpful to know as background is that in 2019, the New York State Legislature passed the Housing Stability and Tenant Protection Act, which is the HSTPA, which expanded the rent stabilization law that was originally only permissible and only existed in New York and Nassau counties, Westchester and Rockland counties. But this New York State Legislature basically created this expansion that allowed any municipality to opt into the rent stabilization law if they complied with this ETPA, the Emergency Tenant Protection Act. But to do that, a municipality had to conduct a survey, gather data to show that the vacancy levels for rent stabilized eligible apartments were less than 5%. If the vacancy is less than 5%, then the municipality may declare a housing emergency and then opt into the ETPA and then sort of start making rules about rent guidelines for those eligible apartments under the ETPA. And generally the apartments that are eligible are in buildings that have 6 units or more that were built before 1974. That's the general rule. Okay, so the facts in this case, and the last thing you have to know is that, the last thing for background is that New York has something called the preservation doctrine, is that you're not allowed to appeal something unless you've preserved the objection or the issue at the lower court. So if you make an objection timely in Supreme Court, in the lowest court, you can then appeal it to the appellate division and then to the Court of Appeals. But if you fail to preserve that issue by an objection or a motion, then you lose the ability to appeal that issue for error at the higher levels of the appellate division and the Court of Appeals. So what are the facts here? The facts are that after the HSTPA was passed in 2019 by the New York State Legislature, the City of Kingston conducted a survey of all the eligible buildings and eligible units in the City of Kingston. And to do that, they prepared the survey. They sent it out to all the building owners for all the housing units that were subject to the potentially subject to the ETPA, using data from local government records to develop a list of residential properties. They announced in the letter that you have to send back a list of the vacancies, the vacant units, so they could figure out if the vacancy rate was below 5%, which would allow them to opt into the ETPA. They also indicated on the documents that if you fail to return this letter, if you fail to let us know, we're going to apply a no vacancy presumption, right? Which would bring it more towards that emergency declaration. So if we get nothing back from you, there'll be a no vacancy presumption if neither the certified mail survey or the follow-up efforts yielded a response. And they did make follow-up efforts, allegedly, to the property owners about whether there were vacancy rates or not, vacancies in their units or not. At the end of that survey in 2019, it turns out that the vacancies were 5.8%, which is above that 5% level. So they could not declare a housing emergency. Okay. Then COVID happens, right? COVID happens subsequently to 2019. And in 2022, now there's demographic changes. Different people are living in Kingston. People have moved in, people have moved out. So the City of Kingston decides to do it again. They decide to do another survey. They're the same guidelines as they did in the 2019 survey. Now the results are a vacancy rate of less than 2%. So now it's less than 2%, which is below the 5% limit. They declare a housing emergency. And in declaring a housing emergency, now they're under the protection of the ETPA, and they can now start passing rules about tenant protections and about rent stabilization and rental rates. So in June 15th of 2022, they declared that they declared the housing rate was below 5% in July 28th. They opted in, and then they created the guidelines board to start creating guidelines, and they created two guidelines. The guidelines essentially created a fair market rent. That was the first guideline, and the second one reduced rent by 15% from a certain amount. It was appealed. The Supreme Court, the property owners didn't like this because landlords don't want to be told the amount of rent they can charge for their tenants. They then filed a lawsuit, this Article 78 proceeding, saying Kingston didn't have the right to declare the emergency, and they didn't have the right to pass these two rules. Ultimately, it goes to the Supreme Court, and the Supreme Court, which is the lowest trial court in New York State, upheld the emergency declaration, holding that petitioners failed to demonstrate that the survey results were unreasonable, but the Supreme Court vacated the two guidelines, the two changes to the actual rental amount. Appellate division goes to the appellate division. The appellate division modified the order by reinstating the challenged guidelines, but otherwise affirmed. It goes to the Court of Appeals, and here, with respect to the declaration, they say the holding here from the Court of Appeals is when a plaintiff challenges an emergency declaration under the ETPA, their burden is to show that the declaration was not based upon reasonably reliant and reliable and relevant measures of the actual vacancy rate. That's the burden on the plaintiff. And here in this case, they failed to meet that burden. Why? Because as the courts listed below, the survey was based upon a list of properties drawn from governmental records. The survey adopted the definition of vacant unit from the statute. The survey used certified mail to ensure delivery. The survey recipients were informed of the no vacancy presumption if they didn't respond. They covered a large majority of the available eligible units, and there were follow-up efforts conducted. For those reasons, it doesn't have to be shown that it's the only possible or the best possible survey methodology, as long as it's a reasonable and reliable and relevant methodology. That's sufficient, and the plaintiffs failed to show it wasn't. Okay, so they fail in that. The declaration stands. There is a housing emergency in Kingston. As to the two rental guidelines, the petitioners claim that the fair market rent guideline had a retroactive effect because it tied the new rent to the 2019 rates, and they say no, that's okay. They say once the HSTPA was passed in 2019, everyone was on notice that it could be tied to the 2019 rent levels. And as to the second fair market rent guideline that would reduce it by 15%, they said that was not preserved below. The Owners Association failed to raise that sufficiently in a timely manner in the lower court. They can't raise it now at the Court of Appeals. So that is sort of kicked, not on its merits, but on the lack of preservation of that issue. And that's the case of the Matter of Hudson Valley Properties Owners Association versus City of Kingston. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.